Welcome to RICO Busters. For this segment here today, I'm going to have John Tatar. John Tatar is a man who has been fighting corruption in government for quite some time. He is a court activist like I have been. He is running for the 11th District for Congress here in Wayne County and Oakland County, Michigan. I don't know if there's any other counties, but I'd like you to welcome John Tatar. Welcome.
Thank you, David. I appreciate being here, and thanks for giving me the opportunity to speak to the public and to you, and cover any kind of questions that we may have and that I can help with.
Well, can we maybe get started about getting into some of your background? I know that, like me, you've been a teacher.
Yes, actually, I taught for 31 years. I retired as a teacher. I taught many different areas: English, social studies, industrial arts, home construction, building trades, building maintenance, wood shop, drafting, and American history and government. Mm-hmm. Spent a lot of time in last 10, 15 years in American history and government, although I built about 19 homes in the city of Livonia with the home construction program.
Wow. So are you originally from Michigan, originally from the Livonia area?
Originally from Michigan. I kind of grew up until about the age of 16 in Detroit, and then moved to Livonia and Redford and bounced back and forth there.
Now, something else that I know about your history, unlike me, is that you have a number of years in the military and in providing service to our country.
Yes, I was in the reserves, Army Reserves, for 31 years. I retired as a lieutenant colonel in the Medical Service Corps. I was activated actually for Desert Storm under George Bush I. And during that time period, I had various assignments. I've been a commander of units and an XO, that's executive officer of battalion and brigade size units, and did a lot of training, a lot of teaching. I was a command and general staff instructor for several years also.
Awesome. Well, and I have a lot of respect for that. I really do appreciate it, and I sometimes wish that I had been able to provide that kind of service militarily for our country. But I feel that we have a camaraderie here in that we're both fighting for what's going on in the court system, which is completely fallen apart here in Michigan. And I was wondering if maybe you could share a little bit more about some of your activism in the courts, what you're finding in the courts. Are you having any success? Because I know I've just hit the wall every time.
You know, when I was a teacher or became a teacher and became a soldier, I took the oath of office and swore to protect the Constitution. And it was about 1970 that I realized I had to read the Constitution and understand it. You know, we all went through high school and the Constitution was read to us by high school teachers. Most of us went through high school without an inkling as to what it really meant. But now when you're swearing an oath to it, that your job and your career is on the line, I took it very seriously. So at that point in time, I started looking at what's going on around me, and I'm saying these things don't fit. They don't fit the Constitution. They don't fit what's going on in our country and with our government. So I started becoming active in those areas, trying to force or push the public functionaries into behaving more constitutional.
And were you finding resistance? Because I'm not seeing that anybody even knows what the Constitution is, you know, and in the government, and they don't understand that the Constitution was designed as a box that's supposed to tell government what to do. Their rights are enunciated rights. They're not supposed to do anything more than what we tell them that they can do. And moreover, the Constitution itself is supposed to be the supreme law of the land, and everything that is derived from that point is supposed to be in a hierarchical fashion, where if the Constitution doesn't authorize it, it's not supposed to exist. Am I right?
That's correct. You did make a comment about my court situations. I have realized that as I deal with attorneys, bar attorneys, law school graduates, that they're really not up to snuff as to how they're supposed to behave and what they're supposed to know and do. They are sidestepping the issues. They're doing the short circuit every time it comes around to answering complaints and answering briefs. They don't get into the real meat of what the laws are. So how can you expect the judges or anybody else to rule in your favor under the law if they don't really understand what the law is and what their Constitution and what their duties as a public functionary is?
Do you find, maybe like I do, I'm certain of this, that they know I think, on one hand, that they know the law so well that they know how to twist it, and that they know how to use color of law to get things accomplished. One of the things that we've been discussing here, and it should be, and I know is a concern of you, and that is how David Trott and his law firm, the Trott and Trott law firm, as well as other foreclosure mills, are behaving and using the law to destroy families, to take people's homes away, along with their equity and their future, and so many other things, by force, because they're working with sheriffs to come out to the home and basically use force to take these people's property away from them. So what are your thoughts about that, as opposed to saying that that they, I believe you on one hand. There's a whole lot of people that don't know about the Constitution, that are in positions of the law. I don't think that the law schools are talking about the Constitution. I think they're talking about how to use case law and all that stuff against people and to win. It's a matter of winning and not a matter of ethics. It's not a matter of truth. And this I think is what lawyers do. What are your thoughts?
I was watching a movie a few days ago, and I can't remember the name of it, but the judge said, the winner of a court case is the attorney that is the best liar. So with that in mind, we're wondering how they know, or how if they've been only taught to win at all expense, regardless of whether it's constitutional or unconstitutional, then the whole system is upside down on its head. We need to bring it back to the system that it was supposed to be in the first place, justice. Mm-hmm. And we know that slogan, justice for all. We don't have that in America anymore. So when you're talking about somebody like Trott, who is only after money, whatever it takes to get his amount of money for that particular foreclosure, he's going to go after it. They don't follow the law. They haven't followed the law. The judges don't follow the law, because the judges are in a lot of cases get their funding for their campaigns through these organizations like Trott and Trott. So when the whole system is tied together like that, and it's all about money and follow the money issue, then it's hard to get justice and hard to get an independent judge to rule for the justice in the court system.
Yeah, they're more ruling for the just us of the state bar.
Exactly.
Right?
Yeah.
It's the just us, and I just heard somebody yesterday saying, their whole family uses the term liars instead of lawyers. That's what they really are, and it has turned out to be terrible.
We know that the Michigan Constitution was passed in 1963, And in 1963, they changed some of the rules in there, some of the laws in there. And one of the laws says that in order to be a judge, you have to be a practicing law for 5 years, good practicing law for 5 years. But in order to practice law in the court system, you have to be a bar attorney. So this is a closed system. So when you're expecting justice from an attorney that writes the law, which David Trott wants to now write the law, he wants to go to Congress, so he's going to write the law, and it's going to be benefiting who? It's going to be benefiting foreclosure mills.
Just us.
That's right. So you're going to have David Trott as the law writer. You're going to have his attorneys that are going to defend the law in court or prosecute the law. And you're going to have the judges on the bench that are part of the bar system that are also going to judge the law. So here you have a system where it's a totally closed system. How can you expect justice in this country?
Well, and so that is why I'm in the courts. We call it pro se sometimes.
Propria persona?
Propria persona, sui juris.
Sui juris, yes.
There's a number, you have to look these words up in the Greek dictionary possibly, but maybe you could, I know you can, help us to understand more about the significance of going into court and all of us, making it incumbent upon all of us to start understanding the Constitution and understanding the rights that we all have, and how so important it is for us to know how to express those rights in a court of law, not just what are these equity courts, these chancery courts.
This is now, since 1933, a court of civil. And I won't get into that today because that's a really long issue. But they've changed the procedure of the court. They've taken it away from law, equity, and chancellery and made it civil. So in the civil court system, the judges now can rule any way they want to rule. And if you come in with a law argument, they go to equity, and if you come in with an equity argument, they go to law. They just flip back and forth. So you have to be prepared to go in there, number one, and get out of the civil when you go into court and fight in the de jure, which brings me to a point. What is facing our country today one of the most important problems, or some of the most important problems facing our country today? And the biggest one is that the public functionaries are not acting de jure. And that's a terminology that was brought out in a case, Supreme Court decision called Norton versus Shelby County. Norton versus Shelby County was a case that was ruled about in Tennessee when the mayor of the city, I'm not sure if it was the mayor, but let's go with the mayor. My mind is not 100% here. The mayor of the city put a commission together to tax the citizens for bond issues so they could raise money for the railroads. Mm-hmm. But this job was already given to the justices of the peace. So the justices of the peace took it to court and said, you know, we already have that job. You can't come up with a commission and do the same job we're doing because it's unconstitutional. And the Supreme Court unanimously said, that's correct. This commission does not exist because it's not constitutional. They are usurpers. They are usurping their authority. They're not de jure. De jure meaning constitutional. And because they're not de jure, they are usurpers. And once they're usurpers, that all their actions are null and void. If I could quote one little phrase in Norton versus Shelby County, which I think is really, really important. It says, an unconstitutional act is not a law. It confers no rights. It imposes no duties. It affords no protection. That is, no protection against the public functionary that is acting outside the law. It creates no office. It is in legal contemplation as inoperative as though it has never been passed. So here they said that the commissioner said, yeah, we're here, we're alive, we meet every month, we make rules. And he said, the Supreme Court said, no, you do not exist. So that brings us to all usurpers in government, all public functionaries that usurp the Constitution do not exist.
And so that, I read that case as well. And like you said, I think everybody should be reading it because it is only 13 pages long. You didn't mention the year. What do you remember?
1886. It was after the Civil War. So we know, and we've been told, or at least through some of the internet sightings that you go on, that the Civil War changed the structure of the country and all of that, but they didn't change the power of the Supreme Court. The Supreme Court's law of the land. Understand that Obamacare was a 4-5 decision, or 5-4 decision. You always say 5-4 decision. This case, Norton versus Shelby County, was a unanimous decision. Every single justice ruled in favor of this definition of terms.
And the de jure, as some people say de jure.
No, it's effective. It's correct to say de jure.
De jure.
That's the way we say it. Yeah.
All right. Thank you. So the jury term is connected to the Constitution, being the supreme law of the land, which means that if if offices are created, if laws are created, any of this stuff that's done without the authority that is granted to from the Constitution, then those are stricken as null and void. They have no effect. Which means that there are, and really, in my belief, I think that the laws that we have, the legislation that we have, not only as it's being legislated, but it needs to be checked against the Constitution with the big question being answered, is this authorized? Should this thing be published or not? You know, does it conform with the Constitution? And you know, we've got administrative law right now. And we've got people that are taking the law in their own hands, and they're depriving people of their rights under this heading of administrative law. Can you give us your views on that?
The point here is that in this particular case, we look at what the law is. If the law is unconstitutional, if it doesn't fit in the Constitution under the authority of the Constitution, they have no authority. Basically, it's I cannot authorize a government official or a government public servant, which terminology is critical here, a government public servant with more power than I have myself. I cannot, for example, make you pay if you were my neighbor, make you do something that I couldn't force you to do. The government can't force you to do that either, because it's a power that I don't have, and I can't administer to the government or give to the government, and they cannot therefore come up with that power to use against you. They cannot come up with a authority more than the authority that I have.
Well, you know something? I think that there is some organizations out there, and I might not mention them quite yet, that are dealing with common law grand juries. And what they're saying is that it's we the people that initiated government in the first place. So, you know, for you to tell us as the common law grand juries that we don't exist, hold on a second, you know, or that we shouldn't exist, or that we have to get our authorization from you in some way whatsoever, you know, I think that kind of gets into a little bit of what you're talking about. Which comes first, the chicken or the egg? Well, you know, in our case, it's the people that came first, and we decided to institute government, and what we instituted, we can take back out again. That's in the Declaration of Independence.
Exactly.
So tell us just a little bit. I want to go back again into your background here and ask you. This is not the first time you've run for public office. I remember you about 4 years ago. It seems 3 or 4 years ago that you were running for public office. I'd like to find out what got you involved in politics and wanting to not only battle things in the courts as a
Propria persona is what I go under, yes.
okay, propria persona. I'm going to have to learn that one. Beside battling the judiciary and what's going on there, and you aren't battling the judiciary per se unless you're finding the corruption in those courts, but you're trying to deal with the issues in the judicial realm, and now I'm seeing that you're also dealing with the legislative realm. And so if you could tell me a little bit more about why you chose this legislative route and why you're running for Congress.
A couple of reasons. You always hear the story, I hate politics. I talk to thousands of people around me, and I hate politics. I don't want to spend, that's not anything I'm interested in doing, so I don't pay any attention to it. They don't understand that politics runs the whole show. Politics is what life is all about. And the definition of politics is the ability to get along. Our government has kind of lost that idea. But in politics, what we're trying to do is to make a system, or to make a nice balance between the right and the wrong and the good and the bad, so on and so forth. Why I got involved in politics and started running for office. And by the way, I run on a libertarian ticket because if you believe that there's a difference between a Democrat or a Republican, then you're sadly mistaken. If
They're
you
both
believe,
sides of the same coin.
exactly. And if you believe that if you vote a Democrat, your Democrat in office, things are going to get better, or if you vote your Republican back in office, things are going to get better, you need to look back at history and say, when have things ever gotten better? Can you name under one administration or one Congress where things have really improved? And I go back to 33, but you can go back a lot further than that. But if you go back to 33 and start looking and saying, where has America really improved? We're still at war. We've always been at war. We'll be at war forever as long as the Democrats and Republicans go in. The economy is shaky, upside down, backwards. We have a Federal Reserve System that is neither federal nor reserve nor a system. It's just a total corrupt money-making business for the bankers. And they're the ones that are creating the wars. So if you think that you're going to vote your man in office and things will be different, then you're fooling yourself, basically. Also, if you think that there's a difference between a conservative and a liberal, or a neocon and a progressive, same thing. Define those terms. Everybody calls themselves, well, I'm a Republican or I'm a Democrat. Well, what does that mean? Can you explain that? What makes you a Democrat, and why would you vote a Democrat? Most people can't give you a definition, or they're going to give you 1 point. They're for the people. What does that mean? So,
a lot of people are calling this a democracy. When this is we've got a republic here. Well, at least we had a republic, and we need to get back to a republic.
We still do have a republic. And as long as we, the people, know we have a republic, and that is where we, the people, have to get educated and understand our power, because we have a vast amount of power against the corrupt government. And Norton versus Shelby County is kind of the linchpin of the whole thing. It defines what a public servant is, how they're supposed to behave, de jure, what happens if they're a usurper, what happens if they are beyond their scope of employment and they're usurping authority beyond their scope of employment. They're personally liable. We don't go after them personally. I do. I'm going after them personally. I'm not going after them through the government. I'm going after them individually. They are the ones that violated the law. The government didn't. The government's this big shield, which is a nothing, which is just a kind of a protection shield. But if they violate their oath of office, if they violate their own job description, they're a usurper, and they're the ones that are violation of the law, and they're the ones that can be prosecuted personally. And that's where we have to go.
Now you're talking.
Yeah.
You're talking personal accountability in government. And with that, I want to take a quick break here. We're going to have a brief discussion, and we'll be right back. Thank you. Welcome back. This is RICO Busters. I've got John Tatar, who's running for Congress here in the 11th District of Michigan, and would like to start where we left off when you were talking about usurpers. Usurpers, to me, imply that they're in a position of authority that's not given to them. And when we start talking about the issues of authority, we start asking ourselves, who's got sovereignty? Who's got the authority? Who is the sovereign authority? And we often see judges getting awarded immunity because and you know, their courts, however you want to define them, being the sovereign, and the government being the sovereign. And when it's really, in my view, it's the people, because we brought the government in. We can take the government out. We can change the government. We can get rid of it by right. That the real help me out here and explaining to the audience about what sovereignty really is, because you know, I've been reading articles about the government, our FBI, issuing statements to law enforcement that describes the sovereign person, an independent thinker, a person who stands on their rights and holds the government to accountability, like you're talking about, to personal accountability. They're calling us sovereign citizens and labeling us as terrorist organizations, because we're trying to strengthen our numbers and to educate the public about what sovereignty really is. Please help me.
Not to get into the terrorist business, but I think that the terrorist business is just business. But let me go back a little bit here and say what the Supreme Court is all about. The Supreme Court is the law of the land. And if you don't know that, you read the Constitution, and it definitely says the Supreme Court is the law of the land. And it says all lower courts, inferior courts, are bound by the decisions of the Supreme Court. They can't get out of it. The judge can't sidestep that. Maybe he can in his courtroom, thinking it's his courtroom, which it isn't. It's the people's courtroom. But let's say it's his courtroom and he sidesteps that issue. Well, that issue is eventually going to come up again, knowing most of the time that if you go to a district court level, you're probably going to lose, because the district court judges are running on their own, playing their own game. So you need to go to at least appeal and maybe even get it to the Supreme Court, because you're really going to not get any justice at a district court judge unless you can really nail the district court judge. But let's say that the lower courts and all inferior courts are bound by the Supreme Court decisions. There is no ifs, ands, or buts about that. Article 4, Section 4 of the United States Constitution guarantees a republic form of government. Guarantees a republic form of government. And Article 6 binds all judges, legislature, and executive branch to the Constitution. So it's a really tight package here. It's not, there's no loose ends that they can jump through, or no loopholes that they can jump through. But you ask the question about sovereignty. Here's a Supreme Court decision. This is called Downs versus Bidwell. Downs versus Bidwell, Justice Matthews said, and this is a 1906 case, I believe.
I think it was.
It says in here, when we consider, this is a little long, but it's important. We will consider the nature and the theory of our institution of government, the principles upon which they are supposed to rest, and view the history of their development. We are constrained to conclude that they do not mean to leave room for the play and action of purely personal and arbitrary power. Now, this part is very important. Sovereignty itself is, of course, not subject to law, for it is the authority and the source of law. But in our system, while sovereign powers are delegated to the agencies of government, here we use that word delegated, they're delegated to the agents of government, sovereignty itself remains with the people.
Thank you, and thank you to our Supreme Court. And that's a good statement right there. And it says it all. It's the sovereignty of the people that has put us, that we have the position innately here in America to institute government and to say, okay, you have these sovereign powers to do this and that, but in all cases they are in a box. Those
This
are
is
enumerated rights.
This is correct. They are
Enunciated.
exactly in a box. There's another point that I would like to point out, and this one is another court case. It's interesting that all of these are Supreme Court decisions. This Supreme Court case is Hale versus Hinkle, and this is a 1906 case. This states, his rights, meaning the people, are, oh, that's the wrong spot. The individuals may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or to the neighbors to divulge his business or to open his doors to the investigation so far as they may intend to incriminate him. He owes no such duty to the state, since he receives nothing from them beyond the protection of his life and property. His rights are such as extended by the laws of the land, long antecedent to the organization of the state, and can only be taken from him by due process of law in accordance with the Constitution. Among his rights are the refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under warrant of law. He owes nothing to the public so long as he does not trespass upon their rights. Here we see we can use that many different ways against Trot and Trot's foreclosure mill.
Oh my gosh. Well, they're taking people's property without due process.
Absolutely.
And as we're proving in other segments of this, they're taking it through fraud, and it's unbelievable, the stuff that they're employing here. What other aspects of Shelby County, since we're on the subject of these court cases, getting back to the Norton versus Shelby County case, if you can kind of give us, the significance of that overall, and I'd like to segue from that to a brief discussion for the rest of the show, perhaps, of what you think that you will be able to glean from this legislation, if you want to call it legislation from the bench, or whether it's interpretation of the Constitution or whatever. What can you glean from that as a congressman, to help us to be assured here, especially in Wayne County and Oakland County too, that rights to due process, constitutional checks and balances on government can be reinstated, because we have no checks and balances right now, and the executive and judicial branches are so torn and broken that I'm calling to accountability from the legislative branch to say, what are you guys going to do about this?
In this country right now, it is the people against the government, or the government against the people. If you believe that the government's going to correct their problems and bring a better America, then you're mistaken. The government is to protect the government. The judges and the attorneys, the Bar Association is to protect the government. They're not to protect the people. So we, the people, have to stand. If we choose not to stand, then we are going to be bulldozed or rolled over, steamrolled over by the government in any way they want to steamroll us. The Supreme Court is very clear as to who's in charge. But the people have to get off the couch and stop watching Dancing with the Stars or some of the other programs and start getting involved, because it's the people that are going to make the difference. If we kind of think about it, there's like, what, maybe 1,000 government employees, a couple of thousand government employees against 350 million Americans. We definitely have the power, in numbers if nothing else, but we have to get the people awake. This Norton versus Shelby County, bringing back to that, has a lot of great quotes in it. One of the great quotes is, officers are created for the benefit of the public. That's what they're there for. Police officers are there for the benefit of the public, not for revenue enhancing, ticketing people on the freeway because they're speeding. We got to understand that the state cannot be a victim. Only a person can be a victim. So when we go to court, the only way that we could really be prosecuted for a crime and pay some sort of a penalty is if we have created injury to another person, not to the state. That's ridiculous.
Well, and think of how often we see in court cases, the people versus so-and-so who was smoking pot on the corner, and, the people are not harmed.
Correct.
In those kind of stuff. A speeding ticket, the people versus so-and-so, well, you were 15 miles out over the speed limit, Who was the harmed party? And I know a lot of people asking that question, who is the harmed party? And how does this judicial system deal with that kind of question? Or do they literally usurp the position of and say, the Constitution's in our hands. We're the ones that's sovereign, and you're just nobody.
They don't usurp the Constitution. They usurp authority. They usurp authority they've never had or were never given. But because they put on the big black robe and they stand on the bench or sit at the bench, and most of the people that face them are afraid of their own shadow, because fear has been taught to us most of our lives. We're afraid of just about everything. So we're also afraid, a lot of people are afraid of the judges. They, I got to go to court, I'm nervous, I'm upset, and they just do whatever the judge wants. But they have to be able to stand on their own 2 feet and say, that they have the power. And I don't mean a power by going in and calling the judge names. That's not going to, or saying that you're a citizen on the land, or any of the other slogans that are given out by the patriots. But really understand the law and really understand why you're there and what's going on. And that does take some learning and some research. I wanted to point out that Norton versus Shelby County says there can be no such court, and they're speaking of the court in Kentucky that they talked about here, that the legislature set up a particular court which was unconstitutional, and they said that there can be no such court as long as the Constitution has life and power. And I use that a lot of times when I go to court. I say there can be no such law as long as the Constitution has life and power. And we know that the Constitution has life and power because every single public functionary swears an oath to it.
So you're doing two things, it seems, tell me if I'm wrong, when you go, maybe more than two things, when you go to court. Number one, you're holding the judge and the officers of the court, whoever has issued an oath of office, their oath to the Constitution, for personal accountability to that oath, number one. Number two, it sounds to me like you are in some ways challenging the laws themselves and the constitutionality of whether this is, and that's what jury nullification is all about. Is that to, I mean, you're if not challenging them, putting them up for question, is that?
The court is all about jurisdiction. What jurisdiction do they have? Do they have a jurisdiction to rule upon you in the civil jurisdiction. And my argument is they only have jurisdiction if you volunteer that jurisdiction. If you choose not to volunteer that jurisdiction and you state it plainly and clearly in your pleadings, by the way, if you go to court, you need to put a pleading in. You don't just walk into court in front of the judge and start talking, because 99% of the time the judge isn't listening to you. So you have to put it on the record. So you put it on the record in a form of a pleading with an affidavit swearing to this, because if you don't swear to it, then it doesn't count. You swear to it, to your pleading, and then you go in front of them, and it's already on the record. Now, if the judge ignores your record, which a lot of judges will do, then you need to go to the next step, not just say, well, you know, I'm going to give up and I was ruled against and therefore I quit. No, you can write the Judicial Tenure Commission. And by the way, the Judicial Tenure Commission is also written up in the Michigan Constitution, and that's a good point that I need to point out. Mm-hmm. It says, on recommendation of the Judicial Tenure Commission. By the way, this is we're looking at, what the heck was it? Article 6, Section 30. It says, on the recommendation of the Judicial Tenure Commission, the Supreme Court may censor, suspend, or with or without salary, retire or remove a judge for conviction of a felony, physical or mental disability which prevents the performance of judicial duties, misconduct in office, persistent failure to perform his duty, habitual intemperance or conduct that is clearly prejudicial to the administration of justice. How much clearer can you get? If you can point out any of those things to the Judicial Tenure Commission, the Judicial Tenure Commission must act.
Well, you know, and the funny thing is that so many of the cases that I've been involved in these courts here, I always hear the word discretion. And the Constitution is saying duty, you know, and so putting these things in the context, you know, it seems that there's this gray area that lawyers and judges like to fill, where we like to, you know, we have what's called rule of law for a reason. So things are put in black and white, but there's this gray area that they're working in that allows the judge to claim discretion, and they will close under color of law this so-called, you know, they say they're doing their duty, but it's totally filled with this discretionary stuff. And if you in fact go to the Judicial Tenure Commission or whatever, they will write, they don't find anything wrong with it because the judge has this broad scope of discretion. And that's a quote from the judicial tenure complaints that I've seen.
The judicial tenure complaints that I've written and I've seen do not have that broad brush painting. Sometimes they will say that they found no evidence of a judge creating or causing problems. However, it's a permanent record on the judge. The next guy that walks up does another permanent record on a judge, and before long, that record becomes fairly thick if the people take it to the next step. But a lot of people give up at the first level and they never go any further than that. They figure that they're going to pay their fine and get away with it and go back and watch football or whatever they're doing. The problem that we have is that people are not taking this, learning what they have to learn and taking it to the level that's necessary. Because there is, I believe, still justice and still a republic here, and we could turn this around on a dime if we choose to do it. But we have to know our rights. We have to know our duties. We have to be able to behave de jure ourselves, that is self-governing and self-regulating, and take away the responsibility of the police department from babysitting us, because we don't want to be babysat. At least I don't want to be babysat. I believe that I am a de jure citizen and I will act de jure. And if I get in office, I will behave de jure because I am de jure.
Fabulous. Well, that's what we need in our leadership. And I do want to take one more quick break, and then when we come back to Mr. Tatar, we're going to ask him to tell us what his leadership is going to be looking like, and what he thinks that this Wayne County, Michigan should be looking like in the future years. We'll be right back. Welcome back to RICO Busters, and we've got Mr. John Tatar here that we have been interviewing, and we'd like to just finish this program today with a little bit of your expression to the audience of what is it going to look like with us referring to you as Representative John Tatar in our Congress for the 11th District here in Michigan. And if you've got any thoughts about why, we won't talk about why David Trott should not be in Congress, but at least anymore, because I think we could go on for hours about that. If you can tell us what you are going to do with your leadership to represent the people and to lead and mentor the rest of us in becoming du jour. You know what I mean?
Well, presently I am running around the neighborhoods working with different types of people, and we're actually having meetings and stuff, and we're talking about the law, and we're talking about being de jure and how to act de jure, and we're talking about Norton, and we're talking about a lot of the Supreme Court decisions that I've already mentioned, and other things, and helping people get involved in the system. That's the problem. We need to bring people into the system. I don't want to be a complaints office where people call up and complain. I want people to be educated and come into the office and bring their knowledge to help the system, to bring the system forward. And if they can't do that, then I will be there with people in my staff that will also be able to help them train and help bring them up to a point that they are, in fact, educated and intelligent enough that they can deal with the system. Again, it brings it all back to the people. The people are the ones that are going to make the change. I will be there as the spearhead or the point of the spear to make things work, to help people get their point across, to help bring people in public functionaries in on the red carpet, so to speak, to talk with them, to find out why they're behaving the way they are and why they're not behaving de jure. And I think a lot of our public functionaries don't understand what de jure means either. They're just elected into a position and they're given a certain line of malarkey, so to speak, to keep it clean, by the powers above them, and they don't have an idea why they're doing what they're doing. They're just doing it and causing problems to the public. We need to make a change. We need to bring the people up in charge as they were. Remember, we started this country. It was the people that formed the Constitution. It was the Constitution that formed the three branches of government. It was the three branches of government that formed the public functionaries that work in those branches, not the other way around. And we have to get back to the grassroots, so to speak, and get the people in charge. So what I will do is I will be their representative, number one. And I can see up all the history of all of the 11th District congressmen that were in office were never representing the people. They were representing their own or personal interests. I have no, or public interests, or oil companies or whatever. I have no desire special interests. Mm-hmm. I have no desire to do that. My desire is to turn the country around and make it a de jure government and a de jure country. Back to the Constitution is what I believe we need to do. Now, a limited Constitution, of course, not extended in the tentacles that we shouldn't be in war. We shouldn't be going after oil. We should be Here's something that I've always said. When the government goes to war, the government is no longer functioning as the politicians of that government. Because remember I said earlier that politicians, or the politics, is the ability to get along. If you can't get along with somebody, then you should be fired. You shouldn't be in that office. So why would we go to war? You wouldn't have to go to war if you can politically talk to other countries, mm-hmm. and make deals and treaties or whatever to benefit everybody, not just to benefit the powers to be.
Well, I think that you explained that very well, and I can just imagine how wonderful it would be to see your office locally and in Washington be places where people can go and coordinate with one another and to converse with one another, and you kind of help facilitate and guide and educate and help people to really understand that we can have a republic. And this is not the democratic rule of the mob kind of thing, you know, the democracy thing, that, and it's not an oligarchy either, where it's the rule of the families and the power players, which is what we have most definitely in Wayne County. So, and it'd be great to have that kind of voice, that local voice in Washington, D.C. too. And so we hope to get you back here, and maybe we can get some more about your various positions that you have on the national issues, local issues. So this is not going to be the last time that, that we have you here, and we'll be looking forward to seeing you back.
Thank you very much.
So thank you very much, everybody, for coming and watching this new rendition of RICO Busters. And we'll see you next time. Thank you.